fee.
All advice given is for general information purposes. All legal cases are different, and you should seek the advice of your own attorney before acting or making decisions. No attorney-client privilege applies to communications on this show, and no attorney-client relationship is created by calling or writing in. Attorney Rominger practices only in Pennsylvania and maintains his primary office in Carlisle, Pennsylvania.
Hey, good afternoon. Carl Rominger coming at you live. 540-0580 is the talk line number. I'm going to be here answering your legal questions. Going to try to keep the shows live for the next month, so we'll keep you posted on that. If things get a little busy, we might have to go to reruns. You guys probably know what I'm talking about. However, today at 2 o'clock, I'm going to have James R. Demmel on. He's an attorney who specializes in, although they're not allowed to advertise and say specialize in, he's not advertising, I'm just saying he does, specializes in collaborative law. It's an area of law that, well, means to work together. And in the collaborative law process, the parties and their attorneys work together to resolve their conflicts by mutual agreement with a commitment to avoid going to court by all the parties. And there's special training and there's special agreements. And he's going to explain it all to us, and you can learn a little bit more about it. It's a concept which is to allow the parties and their attorneys to adequately vet each other's rights with the idea of not having to slug it out in court. Some people think it's cheaper. Some people think it's not cheaper, but less expensive and taxing on the emotional toll that goes into family law, for instance, or other dispute processes between parties. But we'll save all that for 2 o'clock when Attorney Demmel comes on and explains it to us. But I want to give you guys a heads up. So if you have a family, friend member, or somebody you know who's interested in collaborative law or has thought about it, at 2 o'clock today, we're going to have James Demmel on. We're going to learn a lot more about collaborative law, how it works, how you could use it, and who practices it in the central Pennsylvania area. So, again, that'll be all at 2 o'clock. The talk line number you want to call in your legal question now is 540-0580. That's it, 540-0580. You call in, we'll answer it here on the air. Well, we still don't have an answer from the United States Supreme Court on health care. And remember, I'm just keep throwing out there that I'm predicting that John Roberts could be the surprise vote. Now, what a prediction that is. I'm like a real weatherman, right? It could rain tomorrow, but it's only a 40% chance of rain. So if it's sunny all day and you changed your plans, don't blame me.
Aren't all weathermen real?
Yeah, well, I don't know. But Shane, here's the point. The point is, I wish I had a job where I could say with 40% certainty something and everybody paid me to do it, right?
Oh, it's the easiest job in the world. It's the best job to have.
But my point is, if you change your plans based on that 40% certainty and it doesn't pan out, don't blame me because I'm just the weatherman and we're not 100% accurate. We disclosed that with our percentages right up front. Of course, I wouldn't hire a pregnancy test that advertised it was 42% accurate either. Anyhow, the Supreme Court has not decided that case. It has not told us what the answer is going to be. I'm still thinking they will sustain the individual mandate under the necessary and proper clause. So think about that. If, on the other hand, they strike it down, they're going to say that it's beyond the inherent powers of Congress to do it. The next question will be whether they strike down the whole law. And I think that if they do find the individual mandate to be improper, a majority of the court, however, will allow the rest of the law to stand and leave it to Congress to tinker with how to fix it, how much of it to repeal, and how much of it to change or leave, based on their view of how they're going to fund it. But they'll have removed the power of the individual mandate from the situation. 540-0580. Heather, you're on the air.
Hi. I have my boyfriend. He works in the construction industry, and he's not a union worker.
Okay.
And basically, depending on the job, sometimes they would get paid hourly work, and sometimes they would get paid piece rate work. And depending on how many square footage of insulation they would install. And he kept complaining about how his paychecks were always wrong. And every week his paycheck would be wrong. He also got paid mileage for like how many if he traveled like over 40 miles a day, he was supposed to get paid a certain rate. Mm-hmm. So he started complaining and going up to the office and saying, hey, my paycheck's wrong, and they have to submit this paperwork to get the paycheck fixed. And every week he was doing that. And the lady in the office started complaining about he's always up here, he's causing problems. Now, every time he would complain, his paycheck would get corrected. Well, this went on for about 4 months.
Okay.
And finally, he went to work one day and he was let go. He was basically called into the office and he was told, well, we got to fire you. And he was like, why? And they're like, you're causing a disturbance. And he was like, how am I causing a disturbance? And they said, well, it's because, you're always up in the office. And he's like, because I want paid correctly. And lo and behold, like his last paycheck, he looked at the numbers and it was incorrect again. And he went back and he was like, you need to fix my last paycheck. And the manager there of the office basically told him, you'll never work in this company again. I'm so glad to get rid of you and blah, blah, blah. But the whole reason they let him go was because basically other employees started questioning their paychecks too, because everyone knew their paychecks were wrong. He was just the first person to complain, but then he lost his job.
Now they've paid him all his pay, right?
Well, we had a year's worth of paychecks that we had to go back and fight for, but we haven't gone back and fought for the additional pay because it was just it was very time-consuming to do all the math to figure out what was wrong. And we just didn't know if there was any recourse to this because it's just not right.
Well, right. But now let's talk about that. He has two probably primary recourses. One is under the Wage Act to go ahead and sue for any back wages he's owed. Okay. Possibly can be awarded attorney's fees plus additional damages. That's designed to encourage employees to go after those kinds of money and to punish employers for not paying people their wage. Number two, however, would be unemployment.
He filed for unemployment, and they never fought his. And he even put in his unemployment why he was let go.
Right, but they didn't fight it.
They did not fight it. He's been collecting unemployment for about 2-3 months now.
Yeah. So those would be his two remedies, and he could look at going at the Wage Act. But I think other than that, the only other thing to do would be to potentially report the employer to Labor and Industry as well for not paying. But I don't know how that would actually pan out.
Okay. Because, obviously they made an example of him, and from that point on, nobody has gone
right. Well,
to
and that may be a problem. A bunch of employees might not be getting their right pay. The flip side is I don't think he has any, he's not going to get $1 million check or even a $100,000 check for bringing this to anybody's attention, nor is it a personal injury. So I don't think there's going to be any, runaway punitive damages here. But it sounds like, he's good to be separated from this employer.
Oh, definitely. It was well worth it because every week it was a fight, and it just wasn't right. So I don't know.
All right.
Thank you
so
much.
Good luck, Heather.
Thanks.
540-0580 is the talk line number. Barbara, you're on with Carl Rominger. Hi, Barbara.
Hello, Mr. Rominger.
What's going on?
I'm having trouble with the Franklin Township supervisors. They're telling me that they can tell me what I can have on my land and where I can have it.
Well, the short answer is, are they using zoning to tell you that?
They say I have zoning, yes.
Yeah, if your township has zoning, it controls things. I mean, a lot of people don't realize this, but for instance, you can't just put a junk car in your yard if there's zoning that prevents it.
Well, what if your land was there before they had zoning?
Well, if your land was there before they had the zoning, that doesn't help you. But if what you're complaining about was there before you had the zoning, then we say it's grandfathered in.
So grandfather law does work in that case.
It does. So I'll give you an example. If you had a chicken farm and they told you that you could no longer have a chicken farm on that land, as long as you keep the chicken farm in operation, they can't shut it down. Once the land stops being used as a chicken farm, you can never put a chicken farm back if that's what the zoning says. Simple illustration.
So your constitutional rights don't come into play then?
No, zoning's been held to be constitutional. But you know what? You probably should sit down with a lawyer and take a look at what they're trying to have you do. What's their main complaint?
I have things on land that I've had, and I didn't get rid of it off yet. And they want me to get rid of everything I have on land. They want to come up and look at my land and walk over my land. Are they allowed to do that?
They can get access ultimately, and if you won't let them, they get an administrative warrant. Barbara, I got to go to break. Can you hold for 1 minute?
Yep.
All right, hold on. Hey, Shane, you want to... Oh, boy, oh, boy, oh, boy. 540-0580. Reading here about, R.J. Harris stocks the most interesting literature in the world. So he has his In Touch magazine here, which these are magazines that you would never usually find Carl Rominger reading. I'm just going to be honest here. I mean, what do I know? But here's the title. Hollywood Turns on Kim. What a difference a year makes. A year ago, she's a fashion icon. Now she's a nobody. Before she's on the red carpet, now she's the butt of jokes. J-Lo won't hang out with her anymore, and Gwyneth Paltrow finds her tacky. Now I know all that thanks to RJ and his personal reading library. 540-0580. Scott, you're on the air.
Yes. Thanks for taking my calls.
No problem.
I have a property I bought years ago, and fully knowing it's an old property, and before ordinances and grandfathered and stuff, the neighbor next door put an annex on the side of their house that allows them to rent the upstairs in case it's a stairwell. But it's built clear up, right up to the edge, joining my house.
Mm-hmm.
So there's no possible way to even walk through there or anything like that. And now it's starting to settle a little bit, and actually it's landing on my house a little bit. Knowing it was surveyed back when I bought it, there was no encroachment at that point. The bank wasn't worried about it. Wasn't really concerned too much about it. But now it appears like it's definitely a nuisance. It could, if his building catches fire, mine could go up also.
Right, so his building is touching your building.
Basically, the top of the roof is landing on my side of the house. I was wondering if there's anything he can do as far as getting it removed or anything like that. He doesn't rent the upstairs anymore. It's really not much of use of anything, but it is part of his business, part of his house. Okay, so part of the house is. I'm just trying to envision this. So, the top of his house is leaning onto the top of your house, and his top of his annex is leading onto the side of my house. Okay. Interesting. Yeah, I think he would have the right to have an argument that he needs to remove the encroachment. Where's the property line? My house is built right on the property line on the left-hand side. He has a 5-foot setback to his property, but of course he used that 5 foot to build this little annex. So now the houses actually abut each other. Right. So years ago, there were no ordinances as far as setbacks. At that time. Did it 50, 60 years ago. He probably did it. Now, of course, we just had a lady on who's upset about zoning laws restricting what she can do, but this is a perfect example of why we have zoning and setbacks. Exactly, right, sure. Just to prevent these kinds of encroachments from ensuing. Well, at this point, it's probably a nuisance or a hazard, and I think you may be entitled to judicial relief to have him fix it. I would think. And of course, it could be a hazard. You're right. I mean, that's precisely how fire moves from building to building. That's precisely how vermin moves from building to building. I mean, there's a lot of reasons to do it. Importantly of which is someday you're going to want to sell your property. And even if it isn't you, when you're dead and you leave it to me in your will, I'm going to want to sell it. And so we probably want to take care of it, soon in the present. I agree. So what I would start with is a letter to the other guy saying you need to remedy this. And after he doesn't remedy it, then I would start with a court action getting a specific order requiring him to remedy it. Okay. All right. Sounds very good, Carl. Thank you. All right. Hey, take care. We'll give it a go. All right. Bye. You notice me, I have to kind of keep saying, am I envisioning this right? Am I envisioning this right? A lot of times when a lawyer deals with land, we take a view of the land. So I can think back maybe a year and a half ago, I actually got in the car and the judge drove and the other lawyer and I rode along. And of course I sat in the back seat because the other lawyer was senior to me. So that's how that works, He got shotgun, I got the back seat. But you can spread out more in the back seat, right? That's what you can tell yourself. So we rode over to a farm and we literally drove up the farm driveway and we got out and we walked around and, just sort of pointed things out to the judge that we thought were relevant about the land. I guess the parties could have come along, but the agreement was that rather than have the two angry parties who wanted to shoot each other over these boundary disputes and tree lines and fences and things like that, we walked around and just pointed everything out. And the reason we do that is because you can describe an encroachment in court, and witnesses can give you all kinds of testimony, but nothing beats an actual view of the land. And so a lot of property disputes result in the judge going out. I had another judge one time, we had a fight over whether the client was maintaining the right-of-way properly or not. And the idea was that each side had to maintain their portion of it in a way to make it passable. And this is up in the mountains, and it's a hunting area, and none of these are primary residences. And the judge asked permission to do a view without us, and his report back was simply, I was able to take my minivan all the way out and back, and I would think that if I can drive a minivan out and back, the right-of-way is well enough maintained for hunting vehicles. And that was the result there. So anyhow, you want to see it. So that's why I keep asking. I'm trying to get the envision. But what I'm envisioning is one house sort of just shifting over onto the other, which is not good. It means there's a little list or a weakness there. That could be a very expensive repair, but I wouldn't want to be stuck holding the bag on that. 540-0580. Tom, you've been holding the longest.
Carl.
Yeah, what's going on?
One quick question. Can you argue a case in front of the Supreme Court in short pants?
Why does everybody want to ask me this? I guess apparently I was wearing a pair of shorts when I was spotted walking into some kind of judicial facility. But I got news for you. I was actually dressed better than I often am when I don't think I have to go to court.
Well, I guess the paparazzi, they're out there. The other thing, why is that door open inwards? I thought exit doors had to open outwards.
That's an interesting question, because I think every time I try to go into the Pennsylvania Judicial Center, I pull on the door because that's what you're supposed to do at a public building, right?
Right.
I think.
All right. Now, I heard you talking to that lady about a junk car.
Yeah.
Well, these green bags that Waste Management puts out where you put trash in them and fill the bag up?
Yeah.
They sit and they sit and they sit. One's been sitting in our neighborhood for 3 months. I had a delivery route last year, and one was sitting in a driveway probably for 6 months. How long are they allowed to sit there?
Well,
they're more unsightly than a junk car.
Yeah, and I think they shouldn't be allowed to sit there forever. Although interestingly, there should be a general prohibition on trash and refuse, right? But sometimes the way those ordinances are written, as long as it's in a can or covered, I don't know if the borough bag, or in this case the Waste Management bag, counts or not.
I don't know. It just seems they sit and they sit and they sit.
Yeah, they shouldn't be sitting that long. So I would suggest that you could do something about that. I mean, I guess you could tattletale to the zoning officer or the township borough manager or something along those lines, and they may be able to do something about it. But then again, some people like to let that stuff accumulate.
Can I ask you one other question?
Sure. You waited long enough. We'll give you 3 or 4 here.
You're in a parking lot. It's one of these malls.
Uh-huh.
And all over the parking lot, they have stop signs painted on the thing. Legally, what are you obligated to do?
Interesting.
If it's going out onto a highway, you have to obey the stop sign.
You have to.
A parking mall.
On private property or a public parking mall like that, there's actually a statute that talks about it, and I don't know the exact acreage. I think it's 10 or more acres, but I'm not positive. So if there's stop signs in a little parking lot, odds are you don't have to obey them. If it's in a bigger parking lot over a certain size, like most malls and shopping plazas and things like that, bigger ones, then those signs are technically legally binding, and it's a violation of the vehicle code. And there's actually a statute we could look up that tells you how many acres the development has to be.
And they actually went to PennDOT and got permission to put a stop sign.
No, I don't think they had to go to PennDOT. I think what the statute says is that it is a violation of the vehicle code to disobey a traffic control device that was put in as part of a development of more than X acres. And the roads don't have to be dedicated. Think about it this way. It's very interesting is some things it has to be on a roadway of the Commonwealth. Other things have to be on a traffic way. And there's a difference between a roadway and a traffic way, because the idea is a roadway is a road, but a traffic way is just where people usually drive. And so we have a DUI case out there where people used to cut through the Elks parking lot and the guy said, "You can't pull me over in the Elks parking lot. That's not a DUI. It's just a private parking lot." And he's right, except that the court took evidence and determined that that particular parking lot was routinely cut through by people trying to avoid a certain intersection. Therefore, found that it was a traffic way for purposes of public use, and therefore you could get a DUI in that parking lot.
All right. Well, then that answers that question.
But we could look that up. So that's interesting. I think it's 10 or more acres, which isn't a lot of land if you think about it.
No, not really.
Not for a development like we see. I mean, when you get to
Or a mall.
when you get to the mall or the mega Walmart or whatever, those parking lots are 10 acres plus. All right, my friend.
All right, thank you.
540-0580. John.
Hey, Carl.
Yeah.
John here, and I have a problem relating to property. I have recently closed a contract, almost, not settlement, on a piece of property along Chambersburg Road in Gettysburg.
Okay.
Now, the selling people put someone, and no one knows where, someone put a sand mound on one side of the house, which goes over about 2 feet on the neighbor's property.
Mm-hmm.
Now, months ago, weeks ago, or a year or two ago, a person signed a right-of-way on that they would accept that. That paper has been lost, strayed, or stolen. Actually, the attorney handling it died.
Okay.
And his son cannot find that particular document. Now, the person up to this point is refusing to sign a second deed or whatever it would take for me to get this, which means I can't buy the house. And what it is, it's about picture a square, an acre square.
Right.
Having to go over 2 feet, running the length of that one side. And she could sign it, and it really doesn't amount to anything.
Right.
But she says she wants the whole property reassessed so that she doesn't have to pay for that 2 times 400 feet, whatever would happen to be.
Right.
Because the strip isn't good for anything except the strip. It's about 2 lawnmower cuts. Now, my hands are tied, aren't they? I can't see. I can't move. I was flooded out back in September. I don't have a house per se, but everyone says I can rent that home, which I'm about to buy, which I don't want to do.
Right.
I don't know where to turn. The other woman says, "Well, I work for an attorney, and I'm going to do what he says." What do I do?
Hold for the break, and we'll talk about it when we get back.
Sure. I will.
Don't
stay
go
online. Correct?
Don't go anywhere. Yes, just hold on.
You got it.
Oh, I used the opportunity during the break to see if I could find the footage of me in my shorts. I guess he's right. I did. I pulled on that door. I mean, just tried to get in the building and apparently have to push in. I guess if there's a fire in the world, you run into that building. All right. Well, architects are architects. All right, John, you back?
Yes, sir.
Okay. So you want to buy this? Let's do the setup for everybody here. You want to buy some property? I got it.
I already put $1,000 down, the whole 9 yards, under contract. One signature is all it needs, hers, and she's fighting every step of the way.
And here's the issue. For some reason, somebody put a portion of your sand mound on her property, right?
Yes.
And do we know how long? Do we know how long ago that happened?
No one seems to know.
Okay. Well, it was probably more than a day or two ago, right?
Yes. Oh, yeah. It was at least a year.
At least a year or more. The answer is equitably, a court probably could force her to grant you a easement for use of that. But maybe not.
She's saying that she wants I work for an attorney. So therefore, they are saying, I want to close out my mortgage end and have the property reassessed so I don't have to pay extra on his property, meaning mine. How much extra tax is on 2 by 300 feet?
You're not going to be. Wait a minute. She thinks she's going to pay extra taxes because of what?
She thinks that she will get lower tax rate if she cedes that to me, that 200 or 300 foot long. Remember, I told you an acre square times.
Right. So she wants to sell you that land. Is that her plan?
No, it's already been signed. She just wants. She'll give it to me because she doesn't want to pay taxes on that.
Right.
on that strip of land, and she was told negligible pennies, nickels, maybe.
Maybe zero. Let me explain it. Let me explain it to her. I hope she's listening. If you buy 100 acres of land and you pay $10,000 an acre and you subdivide it and you eventually sell it for $100,000 an acre, whether the person gets 0.9 acres or 1.1 acres, it's probably still only going to sell for $100,000 a lot, right?
Yes.
I mean, correct me if I'm wrong, but my point being is that what she forgets is that a lot's a lot because of the setbacks and everything. It doesn't matter if it's 0.9 or 1.1 acres. I mean, obviously there may be a minimum lot size, but I'm sure a township wouldn't care with an issue like this.
So if I contact an attorney and say, let's get something done, and it gets done and she winds up signing it, do I have any recourse to get back the money I am paying this attorney?
Probably not, because she doesn't have to sign it, right?
She's going to have to sign it sooner or later, because the other realtor wants his money, and the owners that are trying to sell it want their money.
And she originally agreed to this, right?
Yes. And
So,
even have her name on a deed or an easement or an assessment somewhere, and none of the people can seem to find because the gentleman is deceased and his son can't locate
so
him.
the only other option to really close this thing down would be to file a declaratory judgment action against her.
Okay.
Asserting that there was, in fact, an agreement and that through inadvertence, the actual document was lost, and you want a court to determine whether or not she actually did sign off on this or not in exchange for whatever was given to her, which who knows what that was. But the point being is that she's already agreed to it, and that there's agreement in place, and then to enforce that agreement and require her to sign a second document so it can be filed.
So either way, I'm going to have to pay for that, or else just wait for her to get off the pot, so to say.
Yeah, but you know what? The letter that says, hey, lady, here's what we're going to do to you. By the way, if you work for an attorney, have him read this.
Well, I have a very dear friend who is also an attorney in Hershey.
Have him write a letter that says, this is what's going to happen to you. I think they'll agree with me that ultimately, if I make an agreement with you, right,
Yeah.
and you take the document, and as you're riding down the road, your son leans over and hits the window button, and the air blows in the car, and it swirls up in the air and lands in the pig pen and disappears all along Interstate 81.
Yes. Gotcha.
It doesn't mean there's no longer an agreement. It just means we've lost the paper copy of the agreement.
Okay. Okay, then I will contact my attorney, and we'll try to get it's as simple as a letter.
Yeah.
Okay.
Listen, you can write her, right? And you can take your horse and you can stick his head in a bucket of water. You can't always make him drink.
Oh, I realize that 100%. But I am just I'm frustrated because I can't do anything.
No, I understand. I understand entirely.
If I even visit the property, technically I'm trespassing. And I said, but I at least own $1,000 of it. So they said, we would love it to work that way, but it doesn't. So.
Right. All right, my friend. John, thank you very much for calling. You have a great weekend.
It's been my pleasure. Take care.
Take care. 540-0580. Steve, you're on the air.
Yeah, hi, Carl. I have a quick question for you.
Yeah.
About a year ago, my girlfriend and I went to a car dealership to buy a vehicle, and we found one, and what happened was we were going to get financing, but in the interim, my girlfriend, who was now my ex-girlfriend, went to her father, loaned like half of the money for the car, and so he went in and put down half for what the vehicle cost, and then we came back in and financed the rest. Now, since we're not together anymore, my girlfriend and I, her father's trying to sue me in small claims court for that money that he put down.
Mm-hmm.
Now, am I liable for that?
Okay. He put the money down.
Asked him for the money. No, I never asked him for the money. I never went to him for a loan or anything, but he's saying that I owe it to him.
Now, let's talk about this. So the money was put down at the time of the original purchase.
Right.
And how long ago was that?
It's been about a year.
Okay. And he wants it back suddenly. What was the event that caused him to want it back now?
Well, We split up.
Right.
Him and me and his daughter were living together at the time.
Right. And now, so he gave some down money out of the blue. He offered to put down some money on the place.
Right.
When he thought you and his daughter were going to live there like a fairy tale happily ever after.
Right. Well, actually, it's a vehicle, a car.
Okay, it's on the car. I'm sorry. On the car when he thought the two of you would be driving around in the car and necking at the movie theater happily ever after.
Right.
And then when things went south, he suddenly recalled that was a loan.
Right.
Now, the party asserting a gift has a duty of doing so by clear and convincing evidence, usually. But there are certain natural ways to prove a gift. And so the reason I asked this or said it that way is to be a little facetious, but we see that quite often. A man and a woman get a gift from one of the parents. They split up, and later somebody starts to assert that money given, the $5,000 I gave you towards the closing on the house, the $2,000 I gave you for this, or the $5,000 I gave you, that was really just a loan, and they were going to pay it back. So the question would be, when was that going to happen, and what were the terms, and when did you actually start paying it back? So I would say you have a pretty strong case to say, no, that was a gift. You know at the time, and we know at the time, and a court's going to infer at the time, you were trying to help your daughter out. And to the extent that that's what that was really all about, we either both owe it to you, which we really don't because it's a gift, or nobody owes it to you because it's a gift. So my first thought is, if it wasn't just a gift, then you and the daughter would owe it both back together, right?
Correct.
But we all know that it was really just a gift, and I think most courts are going to infer that. Now, if you'd signed a written agreement, or he can show that you paid back $100 sometime afterwards, some partial payment back, then that might change the way we look at it. But I think you can naturally prove right on its face that it's a gift.
Okay.
And it's the context we read it in. I mean, it's so common. If heaven forbid I was ever a judge, right? I would just kick back every time I had one of these transactions where somebody put down money on a house or a car or anything when the couple was happy, and then later when they're splitting up, they suddenly assert that it's not a gift or that it's a loan. Absent any proof of a written agreement or repayment of any sort, I think I wouldn't even care at that point, because I would just go, it's a gift. We all know it was a gift, and that's what it was.
Okay.
You got me? Am I making sense?
Yeah, you are.
Yeah, I mean, just think about it. It's everybody's, the young couple's going to sail off into the sunset, so people lavish them. The parents sometimes give them some things, little money in this case for a car, sometimes for a house, sometimes for a vacation, sometimes for a honeymoon, whatever. And I'm not going to believe you when you come back in later and try to tell me it was a loan. It has the natural imprimatur. How am I going to say that? It has the stamp of a gift on it, right on its face.
Okay.
All right, good luck.
All right, thank you, Carl.
Got to go to break. 540-0580. Carl Rominger answering your legal questions. We'll be back to talk about collaborative law with James Demmel at 2, but for another 15 minutes, I'm going to be answering your questions. Oh, I'm back. 540-0580. Carl Rominger here. Of course, in the next hour, we're going to be joined by James R. Demmel. He's an attorney. He practices collaborative law, and he's, I believe, the president of the Collaborative Professionals of Central Pennsylvania, which is a group of collaborative lawyers. Now, I'm gonna wait till he's on, right, to make fun. These guys just want to get along. They want to collaborate. I want to have a trial. I want to fight. I don't know. Now, actually, mediating things and helping clients reach happy decisions is a job of all attorneys. But collaborative law takes it a little bit farther, and we'll talk about that. I often, when I'm talking with clients, weigh things in terms of, trial resolutions. And they say, but I don't want to go to trial, Carl. And I say, no, we're not talking about you going to trial. We're talking about if we carry this to the ultimate resolution, what are the odds of us winning or losing? So those are the sort of things we talk about. But collaborative professionals and collaborative lawyers have a slightly different way of approaching problems, and they make a commitment to that. But we're going to let James kind of explore all that with us, and then hopefully some of you will have questions about how collaborative law might affect your case or how you could get involved with a collaborative lawyer.
I'm not opposed to the process in any way, shape, or form. So I just like to make a little fun of it before he comes on. But I want to make sure you guys do stay. And if you know somebody who's thought about going to see a collaborative lawyer or is making a decision about whether to go with a regular lawyer, whatever that means, or a collaborative lawyer versus the other, well, we're going to have an hour here. And, of course, it goes on podcast, so they'll be able to catch up on it. And, of course, throughout the week, if you need me or any of the attorneys in my law office, you go to romingerlaw.com. That's ROMINGER law.com. Or you can call us at 241-6070. That's 717-241-6070. I always tell people, if you can hear this signal, odds are we've been in your county. I mean, I'm going to Center County this week. I've been to Jefferson County. I've been to Pittsburgh. I've been to Philadelphia. I've been to Erie. I did my own speeding ticket in Mercer County. Did some other litigation in Venango one time. I mean, where else have we been? Up in Schuylkill County. I like it up there. And then north of there, I've been to Sayre. If you guys know where that is, Bradford County. Was I up arguing in Tioga County recently, too, with the Superior Court. Anyhow, so my point is we're not too far away if you want to jump in and help us out, or if you want us to jump in and help you out. We certainly can. And if we can't, I just referred somebody the other day, for instance, he had a custody case out in Huntington, and I'm like, you can pay me to drive there and drive back to do these 1-hour hearings on these things and be out a lot of money, or I can find you somebody up there who's competent, and then if you're local and you want to just run some stuff by me for a second opinion, it'll save you a lot of money, and that's what we're going to do. So quite often we can help you coordinate with counsel as well. John, you're on the air.
Hey, Carl.
Hey.
Hey, yesterday my granddaughter was visiting her father.
Mm-hmm.
They shared custody. He's had it for 13 years because her mother and him were never married.
Mm-hmm.
And they're fine. Well, she remarried and had 2 children to another man. Yesterday, this man shows up with a couple police cars with 7 pages of paper and said my 13-year-old granddaughter had to go with him to an undisclosed location because he's going through a divorce with my son's ex.
Mm-hmm.
And my son didn't know what's going on because he has nothing to do with this. My granddaughter wants to be with him, and he don't understand what's going on. So the police and her stepfather took her away to this undisclosed location, and we got to looking at the papers, and all it is a bunch of accusations against her mother. It's not signed by a judge. It's not signed by a lawyer. But they took my granddaughter away. So after we got down to sit down and read this, we thought, well, shouldn't that be signed by a judge?
Where is she now?
We don't know.
Huh.
Yeah.
Well, I call that a kidnapping. Now, what do the police say?
They told my son to stay out of it. She has to go. And I thought, well, the police should know better than to serve papers that, to me, don't seem legit. There's not a seal on them.
What's the custody order say?
This is Lancaster.
Yeah, but is there a custody order?
It was just had an Esquire's name on it.
No, not the paperwork they showed. I'm asking, does your son have custody of his daughter?
Did he sign over custody? No way.
No, does he have a custody order right now?
Yeah, shared custody with her mother. Yeah.
Okay, so whose custody is it right now?
Her mother's. So, and her mother doesn't even know where she's at either. This guy just came and took her away.
So that would be the mother's custody right now, not your son's custody.
Right. They have shared custody, but she was just visiting for the weekend.
Okay, I'm just trying to figure out who's supposed to have the kid right now. Mother is, and mother doesn't have the kid.
Right, correct.
Well,
and the mother doesn't even know where the kid is. As a matter of fact, he even took the other 2 kids. He has all 3 children at an undisclosed location now.
Well, what police department was involved with this?
Can I say it?
Yeah, well, go ahead.
Columbia.
Well, I would suggest that your son gets a lawyer and they immediately get in touch with the Columbia police. Number 2, I would suggest that an emergency court order be filed asking for the return of the child. And I can't imagine now, the allegations are against the daughter or against your son?
Allegations against
the mother.
The mother, not
Right.
against my son. My son had nothing to do with it.
Well, this guy has no right to custody whatsoever. He's a stepfather, right?
Yes.
Yeah.
He's no blood to her.
This makes no sense whatsoever.
Well, that's what I thought, and I thought, what the heck? I'll call Carl and see what he says.
Now, I would get a lawyer on it like first thing Monday morning.
Okay.
Yeah, and maybe somebody can get paddled here. To me, that seems like interference with custody of minor. I don't know why the police would be aiding and abetting that. Because here's what usually happens. Let's say there are some horrible, heinous allegations against mom that might or might not be true.
Right.
Usually children and youth or the police would say, Dad, I know you got split custody with mom, but we want you to keep the kid until we check this out and figure it out.
Correct.
Not stepdad run off with the kids to a, quote, undisclosed location.
Oh, yeah, he took them away. Nobody knows where all three of the kids are now. My son doesn't even know
Right.
where his daughter's at. So
Yeah, he needs to jump on it. Right. What day did that happen?
that happened Friday, yesterday.
Yeah, absolutely. I'd also start with the Columbia Police. You guys might want to call them and say, "Hey, where's my kid?"
Yeah.
And tell them to call. Yeah, call them now and say they get to call on the radio show. And I'll talk to them on the air.
Yeah, right.
We'll see if they're willing to do it. That doesn't make sense.
would.
Some poor officer probably got bamboozled.
Well, yeah, because you just don't hand papers over and take kids out for no legitimate reason. I don't.
Now, unless there's an absolute court order, and a court order would be signed. At least, even if there's an erased seal, it would be signed.
Well, no race seal, no signature, no. At the bottom, it has like a blank for a judge to sign. No judge. All it has is some esquire.
Yeah,
in
some lawyer.
In Lancaster, some esquire. What's esquire? That's a lawyer, right?
That's a lawyer. That's just a lawyer. That's right. All right, go get him, brother.
All right, thanks, Carl.
Oy vey. That doesn't sound right. That doesn't make any sense whatsoever. So either we're missing an essential fact or somebody kidnapped some kids. 540-0580. When I return, we're going to be talking with Jim Demmel about collaborative law. I'll see you guys in a couple minutes.